Welcome to our deep dive on navigating immigration status shifts, especially the move from H-1B to F-1 student status. First, we will set the stage by explaining the 60-day grace period after job loss on H-1B. Next, we will unpack the critical concept of intent, dual intent for H-1B versus single, non-immigrant intent for F-1. Then, we will examine why pending I-140 immigrant petitions are a red flag that often dooms a change of status to F-1. Finally, we will explore safer alternatives, risk mitigation strategies, and realistic timelines, followed by a quick quiz and key takeaways. Let's begin. Here is our roadmap. First, we will cover the context and the 60-day grace period. Next, we will define dual intent versus single intent. Then, we will analyze the I-140 red flag. After that, we will present safer alternatives with timelines, a decision flow, practical steps, and a documents checklist. Finally, we will test your knowledge with a short quiz and wrap up with key points. Before we go further, a disclaimer. This video provides educational information only and does not constitute legal advice. Immigration rules can change, and individual facts matter. Therefore, you should consult a qualified immigration attorney for advice tailored to your circumstances. With that clarified, let's proceed to the 60-day grace period context. When an H-1B worker loses their job, an immediate 60-day grace period begins. During this window, it is crucial to maintain lawful presence by taking concrete action. Practically, that means you should promptly explore an H-1B transfer with a new employer, consider a change of status if applicable, or plan consular processing or departure if necessary. The key is that by day 61, if no status-preserving action has been taken, the individual risks being out of status. Next, we will clarify the core idea of immigration intent that drives most outcomes in these cases. Let's define intent. H-1B recognizes dual intent. You may be in the United States temporarily to work, while also intending to pursue permanent residency. By contrast, F-1 student status requires a clear, non-immigrant intent. Your primary purpose must be study with a plan to depart the United States after your program. When you attempt to move from H-1B to F-1, you move from a dual intent framework to a single intent framework. If evidence in your record points to immigrant intent, such as pending immigrant petitions, that conflict will often trigger heightened scrutiny and lead to denials. Next, we will examine why a pending I-140 is especially problematic. The presence of one or more pending I-140 immigrant petitions is a major red flag when seeking a change of status from H-1B to F-1. USCIS officers examine the totality of circumstances. A pending I-140 is a concrete step toward permanent residence, which strongly suggests immigrant intent. Even if you have not filed the I-485 adjustment application, the I-140 itself can be persuasive evidence of long-term immigration goals. Consequently, F-1 change of status requests in this posture frequently attract requests for evidence or outright denials for lack of non-immigrant intent. Now, let's transition to safer alternatives and ways to reduce risk. This flowchart begins at day 0, the moment of job loss on H-1B. The first decision is whether you are within the 60-day grace period. If yes, the best branch is to secure a new H-1B employer and file a transfer, ideally cap-exempt if possible, to maintain dual intent without interruption. If no new H-1B employer is available, the next decision considers whether you have a pending I-140. If you do, an F-1 change of status carries high denial risk due to immigrant intent. You may evaluate consular processing abroad for F-1 or consider other non-immigrant statuses such as B-2 or J-1, but the single intent requirement means the I-140 still creates a risk of denial. If you choose consular processing, a denial abroad is likely but does not jeopardize an in-U.S. status because you would be outside the United States at the time of decision. If you do not have an I-140, an F-1 change of status may be possible, but you must still prove non-immigrant intent. Finally, if you are beyond the 60-day grace period, you face out-of-status risk and should urgently consult counsel. Let's compare options. An H-1B transfer, particularly if cap-exempt, is the safest for continuity and preserves dual intent. An F-1 change of status inside the United States is high risk when you have a pending I-140, because it conflicts with the single intent requirement. Pursuing F-1 at a consulate abroad can still be denied, but the denial occurs outside the United States, which avoids in-country status issues. Switching to B2 visitor or J1 exchange status can bridge gaps, yet both are single intent categories, so the I-140 continues to be a problem. Some J1 categories also impose a 2-year home residency requirement, which can complicate future plans. Overall, the H-1B transfer stands out as the most reliable path when possible. Here is a practical plan. First, confirm your last day of employment and compute your 60-day deadline. Next, consult an immigration attorney immediately to tailor a strategy. Prioritize an H-1B transfer by engaging recruiters and professional networks. If transfer options do not materialize, evaluate the trade-offs between seeking F-1 via consular processing or using a short-term bridge status. If you do pursue F-1 study, coordinate program start dates, SEVIS issuance, and travel plans carefully. Maintain well-organized documentation for potential requests for evidence. Finally, establish a contingency plan to depart before day 61, if no lawful status path remains available. This table lists common documents and their purposes. Your I-94 and prior approvals establish your status history. Termination evidence helps verify when the 60-day grace period begins. A job offer and certified labor condition application support an H-1B transfer. For F-1, you need an I-20 and proof of SEVIS fee payment. I-140 receipts or approvals must be disclosed and are central to assessing risk. Financial proof may be required to demonstrate ability to study without unauthorized employment. Travel history and prior visas inform consular strategies. Finally, an attorney-prepared letter and exhibits can help address non-immigrant intent, though this remains challenging when an I-140 is pending. Looking ahead, if you secure a new job after moving into F-1 or another status, switching back to H-1B is generally straightforward, because H-1B allows dual intent. That means your I-140 is no longer a barrier for the H-1B change of status itself. However, the real difficulty is staying in lawful status until that new H-1B petition can be filed and approved. This timing challenge is often why the initial shift to F-1 becomes impractical in the presence of immigrant petitions. Next, let's test your understanding with a quick quiz. Question: which scenario is most likely to be denied for F-1 change of status? Option A: no I-140 on file with a clear study plan and strong home ties. Option B: A pending I-140 while seeking F-1 change of status inside the United States. Option C: an approved H-1B transfer filed within the 60-day period. Option D: departing the United States to apply for F-1 with no immigrant filings. You may pause the video now to consider your answer. We will discuss the correct answer in the next section. The correct answer is B. A pending I-140 strongly indicates immigrant intent, which conflicts with the F-1 requirement for non-immigrant intent, making an in-country change of status particularly susceptible to requests for evidence and denials. By contrast, a case with no immigrant filings and strong ties may be approvable, and an H-1B transfer maintains dual intent. Consular F-1 with no immigrant filings could still be scrutinized but does not suffer from the I-140 conflict. This sequence illustrates a common pattern. The worker files an F-1 change of status around day 10s. By day 45, USCIS issues a request for evidence that references a pending I-140 and questions non-immigrant intent. The worker adjusts the program start date with the school and updates SEVIS. Meanwhile, a new employer appears around day 55 and prepares an H-1B transfer, ideally filed in premium processing by day 58. If timely and eligible, the transfer can be approved even if the F-1 change of status later faces denial. Ultimately, success hinges on filing dates, maintaining lawful presence, and precise coordination with CVIS records and employer filings. Next, let's consolidate the main takeaways. The essential points are as follows. First, the 60-day grace period requires quick and strategic action. Second, H-1B permits dual intent, while F-1 requires single, non-immigrant intent, and conflicts between these frameworks are often decisive. Third, a pending I-140 substantially undermines the viability of an F-1 change of status. Fourth, the safest path is usually an H-1B transfer, while alternatives involve single intent risks. Fifth, consular F-1 applications still encounter high denial rates, but a denial abroad avoids jeopardizing an in-country status. Finally, maintaining lawful status and rigorous documentation at each step is critical. To summarize, act early within the 60-day grace period and map your timeline carefully. Whenever possible, prefer an H-1B transfer to preserve dual intent. If you have a pending I-140, assume that an F-1 change of status is high risk. If necessary, evaluate consular processing and short-term bridge statuses, but do so cautiously, given the single intent hurdle. Throughout, keep impeccable records and be ready to respond to requests for evidence. In a moment, we will close with a final note and a call to action. Thank you for watching. If you found this helpful, please like the video, share it with someone who needs it, and subscribe for more practical immigration insights. Finally, share your questions and experiences in the comments so we can continue the conversation.